Wouldn't it be better to train than to have lawsuits? If you have better training, won't you have less lawsuits?
Our uniform services, I think 3 or 4 years ago, we had less than $2,000 training for 100 cops. The problem is then we start using that money for conferences. I think
The money gets moved around, training gets cut.
Although I can be fired and although I can do prison time, you can't take the house from my family. That's what qualified me. It's not to get cops out of trouble. And that's a big thing when they're like, I want to get rid of qualified immunity. Nobody is going to put their family at risk. Like, I respond to your house. It's a home invasion. It's dark, and I'm a new guy. I'm not trained. And you open the door to go, dude, I saw it, and I put 5 in your chest, and you're dead, right? That's human error. That's going to happen. That's not because you had a robot that can't do data analytics within a millisecond and know that you're not the threat.
Right.
He is going to face from everything from a write-up to incarceration, right? Qualified immunity means that you can't come after his family for his house because of something that he did to you.
Right.
Where if it was, a lawsuit in the civilian world, you can come after anybody, all their assets and everything. I'm one bad call away from being jobless and also losing my house. And so it's just going to be a judgment call. Hey, this profession isn't worth it. I'm putting myself out there every day for these lawsuits.
Welcome back, everybody. As many of you guys know, I'm a law enforcement trainer instructor. I train and instruct military and law enforcement all over the country on various law enforcement disciplines to include constitutional law, case law, patrol tactics, use of force, advanced criminal investigations, etc. And here we're going to be responding to Copville and the Anti-Hero podcast. Now, I know there's a lot going on with these entities, and let me just say first off, we're going to be addressing their qualified immunity statements, right? I know that Anti-Hero is going through some, I don't know. I really don't know. I just know there's allegations of everything from prostitution with people that don't know their gender, right? Transgender, whatever you want to call that. And then there's some allegations of domestic violence. Again, don't know any of it. Don't care to know any of it. That is not what this video is going to be addressing. This video is going to be addressing nothing but the statements they made as far as case law and qualified immunity particularly. And so I say that to say, again, I don't know these. I don't know these gentlemen personally. I'm finding that I know people that know them, right? There's some nexuses there, but as far as me personally, never met them, never talked to them. But based upon the statements that they have freely made in their podcast, I'm just going to say that I will respectfully 100% disagree with their contentions as it relates to qualified immunity. And this isn't surprising. Most citizens don't understand qualified immunity. They understand the word and they kind of have a basic understanding, or they think they have a basic understanding of, well, cops can do whatever they want. That's pretty much the idea that many citizens have of qualified immunity. And then cops, by and large, have an even bigger, deflated, incorrect issue of qualified immunity, kind of like this individual here. Again, he has made some statements that qualified immunity, the whole purpose of it is not to get you out of trouble or crime. It's just so they can't take your house from your kids and family. I have no idea where this idea comes from. I have no idea what case law articulation that he has, but it's absolutely wrong. And then here, I'll just put kind of a screenshot here, and I think you saw the screenshot earlier, but I'll re-put it up. Basically, somebody stating that in California, even if you make an arrest, even if it's lawful, if the district attorney fails to file or pursue charges, then they can come after your qualified immunity and civilly sue you and come after you. Again, no idea where this is. I have no idea where this is found in case law. I have no idea where this is stated in case law. I have no idea. I have case law on the Supreme Court level to show the opposite, but I have no idea where these guys are getting this stuff from. So again, with all that to say, let's just come at it. Let's just come at it for what it is. So I think the first case law, we're going to go in order here. We're going to go in order as it relates to case law in time, right? Date and time. So let's start with Malley v. Briggs, 1986. What happens if a arrest is found unconstitutional Well, the Supreme Court said an officer may be civilly sued for monetary damages by the victim of an unlawful arrest. The Supreme Court has determined that the question is whether a reasonably trained officer in the petitioner's position would have known that affidavit failed to establish probable cause and that they should have applied for a warrant. If such was the case, the application of the warrant was not objectively reasonable because it was created unnecessarily danger of an unlawful arrest. Therefore, the officer would not be entitled to qualified immunity. So again, we're going to see this word play out numerous times, and I'll kind of give you my opinion on that. I highly encourage you to speak to a lawyer, and I've talked to many lawyers about this. And so based upon my training experience, based upon my education experience, and also based upon talking to lots of criminal law attorney subject matter experts, I'll relate to you what my opinion on it is. Because if we're honest, the Supreme Court has never established what the standard for a reasonably well-trained officer was, right? There's no minimum standard that the Supreme Court, the SCOTUS, has stated is, right? And so that's going to come into questions as regards to, is a California Post police officer a reasonable officer? Is a Oregon DPSST officer a reasonable officer? Is a Texas TCOL officer a reasonable officer? Is an Oklahoma CLEAT officer a reasonable officer? So again, SCOTUS has never stated what the minimum standard was. So that's important to know. Next, we have Anderson versus Creighton, 1987. What if a seizure is found unconstitutional? The Supreme Court held that an officer who conducts a search that violates the Fourth Amendment is entitled to qualified immunity if the officer provides that a reasonable officer would have believed that the search constitutionally complied with the Fourth Amendment. The relevant question that a court should ask whether a reasonable officer would have believed the warrantless search to be lawful, considering clearly established law and the information which the officer possessed. The Supreme Court also held that subjective beliefs about search are relevant, right? So that's important. The Supreme Court has also held that subjective beliefs about searches are relevant, which is good because it's not about what my subjective belief on a search is. It's what, and you're going to hear me say this again, the conformity to standards is. And again, Anderson versus Creighton, 1987. Now, let's move to a newer case law, a Supreme Court case law as it relates to qualified immunity. And this is going to be the big one. This is kind of the big overarching one. And it's Pearson versus Callahan, 2009, the doctrine of qualified immunity. Qualified immunity is a type of immunity that protects a government official from lawsuits alleging that the official violated a plaintiff's rights, only allowing suits where officials violated a clearly established statutory or constitutional right. Qualified immunity balances two interests: the need to hold public officials accountable when they exercise power irresponsibly, the need to shield officials from harassment, distraction, and liability when they perform their duties reasonably. And again, we have this reasonability standard. So again, just to give you my perspective and to answer my question, just to answer the question that I would state, a reasonable officer, again, there is no minimum standard. SCOTUS has not stated that this is the minimum standard for a reasonable officer, but you can never go wrong if you are in compliance with the Supreme Court case precedents. So if your arrest that you make is 100% standing and pursuant to Supreme Court case precedents as established by SCOTUS, I don't see how you can be wrong. Now, with that comes, and that means that officers, by and large, as a culture, are probably going to have to change how they look at this. And the reason why I say that is because let's talk about basic report writing, right? Whenever I write a report, if it's it could be any kind of report, right? Something as minimal as public intox, something as egregious as an ICAT case. I list every element of reasonable articulable suspicion I have. I list every probable cause element that I have, and then I attach each element to a court case precedent, whether that court case is state, district, or Supreme Court. Now, most officers, 99% of officers do not do that, and that's fine. But I'm telling you, if you get my report and you're a defense attorney, you're going to have a very, very difficult time stating that I didn't have reasonable suspicion or probable cause, because each element is going to be attached to a Supreme Court case precedent or a circuit court case precedent or a state precedent. So in order for you to come after me, you're going to have to argue why all the other court cases, including the Supreme Court, were wrong. Good luck. Good luck. That's why I do things the way I do, because you're never going to be able to state I acted unreasonably when every articulation is tied to a reasonable court case precedence. So for a lot of people, they're like, that's too much work. That's fine. Me, I don't think it's too much work for really one reason. Court cases have already been established. It's literally copy and paste, right? I've done enough of these where I have a whole list of elements, and the elements are already attached. So I don't even have to type it out. I just have to find it. Oh, there it is, copy paste. Oh, there it is, copy paste. So it's not difficult because the case precedence has already been established, right? So we're not reinventing the wheel at all. There's no reinventing the wheel because it's already been established. I'm not establishing anything new. I'm just taking what's already been establishing and stating, yes, this is established case law and I used it. Again, not everybody's going to do that, and that's fine. I'm not everybody. But as far as, what is a reasonable officer? A reasonable officer adheres to Constitution court case precedents. I mean, really simple. So even if I was in California and let's say I made an arrest, let's say I made a public intox arrest, right? And I, did everything. Every element's attached, got a blood warrant, the whole 9 yards. Yes, I have no problem doing a blood warrant for public intox. Again, it's easy. It takes me 30 minutes tops. So there you go. I have established all the elements, but let's say the DA's like, man, it's his first offense. We're just going to drop it to this, or we're going to do this, or in the interest of whatever. Cool. They're not going to be able to come after me and say, well, since the DA dropped it, you're now liable. No, take a look at that. Take a look at that binder. If you want to come after me, let's do it. But it's there. And again, I have that confidence only because I only use court case precedents, right? So it's pretty easy to have confidence in something that you are 100% taking from prior court cases to include the United States Supreme Court, especially when it comes to public intox or DUI. There's so many Supreme Court case precedents on it. It's pretty easy. Again, all I'm doing is saying, well, the Supreme Court said this, Supreme Court said that, Supreme Court affirmed this. So if you have a problem with it, you should probably talk to the Supreme Court counselor. So that is, by and large, the Supreme Court case precedents holding of qualified immunity. Now, he was making some mention of, well, you can get into a shooting and let's say a rookie cop doesn't have the training and he goes and just somebody opens the door and he unlawfully uses lethal force and kills the homeowner. Qualified immunity would, he may get in trouble, he may, get everything from a ride up to jail time, but he'll be able to keep his house. Again, no idea where this comes from. I have no idea where this is seen anywhere in case law. So let me just show you the case laws that are out there, and I'll let the smart people that are watching, so you can make up your own mind. So let's talk about Inkenbusi versus Bolter, 1999. The court decided was reasonable. So the First Circuit, a court affirmed that Police Sergeant Bolter did not have the authority to arrest a journalist for filming at a Pembroke Town Hall meeting and the public officials talking in the hallway following that same meeting. Sergeant Bolter was following instructions, just following orders from commissioners of Pembroke Historic District Commission. Sergeant Bolter lost his qualified immunity. The First Circuit held that a reasonable officer would not find that the peaceful activities of a journalist amounted to engaging in disorderly conduct or disturbing a public assembly. The First Circuit affirmed that a police officer is not a law unto himself and cannot give an order that has no colorable legal basis and arrest that person who defines it. So if we look at this, let's just weigh it, right? A rookie officer, who cares? He's an officer, he's sworn, he's on the road. It doesn't matter. Unfortunately, he could be 20 years on the job. He could be 3 minutes on the job. He's acting under the color law of a sworn police officer. So let's just take that for what it is. So a police officer is up on a door. Homeowner opens the door without any grant factors, without any legal justification. Bam, unloads. Well, I hate to break it to you. If we're comparing, right, this sergeant arrested somebody for publicly filming, lost his qualified immunity. You, or this officer, right, double tap somebody, uses lethal force, kills that person. Do you think they're going to get qualified immunity? Again, we're just weighing the two here, right? So if he's not granted qualified immunity, is he probably going to lose his house if they decide to go that way? Yeah. Why wouldn't he? Also, you can't maintain qualified immunity and still be found criminally. You can't face jail time and face criminal charges and still lose your qualified immunity. That doesn't work, because therefore he didn't have his qualified immunity, right? This idea that, this officer is going to, federal jail or prison for manslaughter. Oh, but yeah, he's going to keep his qualified immunity. Again, I don't know where this is coming from. I don't understand this guy's. I don't know what case law he's spouting, but I'd be curious. I'd be curious to know. Let's talk about another one. The Sixth Circuit ruled that Officer Joseph Schuzman arrested a man for disorderly conduct after he called the officer a, I quote, son of a bitch and a fat slob. This officer, Officer Joseph Schuzman, was not entitled to qualified immunity from a federal civil rights claim. The arrestee, Kennedy Kenneth, voice, may not have been loud enough to be unreasonable, and Officer Schuzman's decision to arrest him may have been motivated by retaliation against the arrestee for exercising First Amendment rights. Again, Kenneth versus City of Villa Hills, Kentucky, Sixth Circuit, 2011. Cool. Let's look at another one. We have so many of them. Let's just look at one more. Police chief loses qualified immunity. A district court denied qualified immunity to a police chief who stopped a freelance photographer from taking pictures of a car accident because the recording was protected under the First Amendment. Connell versus Town of Hudson. So we look at this. We see a police chief lost qualified immunity for arresting somebody again for taking photos of a car accident. So again, if we're just relaying this, right? And we're going to talk about this here in a second. Law enforcement officers lose qualified immunity all the time. So if you illegally use deadly force, and we have the most recent Barnes versus Felix 2025 Supreme Court case precedents, especially as it relates to excessive use of force. So we can see unlawfully killing somebody with no justification, arresting somebody for First Amendment, right? If you can lose qualified immunity and be the police chief for arresting somebody for exercising the First Amendment, and then you shoot somebody and kill somebody without legal justification, right? Like, again, let's just call it what it is. And if you want a great example of the use of force one, Barnes versus Felix was a great example because even it was a traffic stop. So he, at the time, he was legally seized, right? So again, Barnes versus Felix, 2025 versus this hypothetical rookie cop shooting somebody without lawful authority in their own home. Just throwing it out there. Again, I have no idea where this Copville anti-hero guy is getting his stuff from. I don't know, but all right. So let's look at some qualified immunity legislation real quick. Let's just knock this out real quick. As you can see on your screen, Colorado got rid of qualified immunity in 2020. New Mexico in 2021. New York City in 2021. Nevada Supreme Court 2022, and Vermont in 2019. So we already see that qualified immunity is going away. Like it or not, that's just kind of where we're at. If we look at in the past 3 years alone, there have been 35 states who have introduced qualified immunity bills. A Washington Post found that police misconduct cost taxpayers more than $3 billion since 2020, with more than $1.5 billion of that to settle claims against officers who had more than one claim against them. And again, most of this stuff is coming from the bigger cities, right? Because if we look at this logically, a lot of these cities have what's called, and most places have what's called indemnification, which basically means to indemnify, which means the police officers, even without qualified immunity, they're not going to be held liable. The cities are going to be held liable because there's already laws in place that state that the cities would have to cover if they're acting as a city employee or state employee or county employee, etc. So take that for what it is. Let's look at another one, qualified immunity statistics. Qualified immunity disadvantages victims of government abuse in other ways. All these issues lead to governmental defendants winning more than they're losing. So if we look at it, circuits grant qualified immunity in 54% of appeals and deny it in just 26%, and that's going to be mixed depending on your circuits. An example of that, the 4th and 6th circuits denied qualified immunity to officers 41% of the time. So in the 4th and 6th circuits, almost half the time, so almost 50%, of cops lose their qualified immunity. And then in the 5th Circuit, qualified immunity is just denied 16%. So it's mixed. And again, that's going to be based upon so many factors because, again, every case is going to be unique. But again, this idea that officers never lose qualified immunity is not backed by the statistics. And there's a lot of reasons why some people may feel like, well, why didn't that officer lose qualified immunity? And again, a lot of that has to come down to the pressure of the victim, right? If you're a victim of police brutality, right, excessive use of force, whatever, but you don't ever pursue anything, how do you expect qualified immunity to be removed, right? If you never pursue it, it doesn't just automatically start or go away. right? Qualified immunity is something that has to be requested, right? So an officer just doesn't automatically have qualified immunity. That's what a lot of people don't realize. It needs to be granted or not granted. So again, I think that's one big thing. People think, well, officers automatically have it. That's not true. It has to be applied for. So if an officer does something bad and victim never pursues anything, then there's nothing for the officer to apply for. So I think that's something that we also have to be honest with ourselves about. Again, people don't like that. That's fine. I'm not here to make you feel any better or any worse about it. I'm just here to give you the factual truth here. So again, qualified immunity is not automatic. This idea that it's automatic is just factually incorrect. So understanding this, we have to realize that qualified immunity is one of those, it's going to be one of those hot topic issues. And there's a lot of First Amendment activists that really don't want qualified immunity to go away because payouts would significantly decrease. Because if we had a way where officers were automatically held liable, and again, I'm not saying I'm against that, but you can expect significant pay increases to go away dramatically. And you can expect that to happen pretty much overnight. Because if there's no indemnification, right? So if cities can't indemnify their employees, well, how much do you expect to get paid out by the officer that makes $17.50 an hour? And I'm using that because there's a lot of officers, for example, in Oklahoma, laterals, that are making $17.50 an hour with no, medical benefits for dependents. I know because I came from an agency like that. So what are you really expecting to get from these officers? Your payout's not going to be really anything. So most people especially people that do this for a living, want to be able to go after the city, right? And so that's also something to keep in mind. So again, so when we're talking about, well, what is a reasonable officer? Again, SCOTUS has never defined what a reasonable officer is. That's never been defined. But I would say, based upon my training experience and based upon the conversations that I've had, it's adherence to standards. If you are adhering to the Supreme Court standards, because the Supreme Court is the only entity allowed to make interpretations for the Constitution. So if everything that you're doing is backed up by the Supreme Court, backed up by the 10th Circuit, backed up by Supreme Court case precedences and case precedences in which your jurisdiction is, that would be a reasonable officer by and large. Again, if everything that you're doing is backed by Supreme Court case precedents or backed by precedents and is lawful, you're fine. When you start getting into the weeds is when you start doing what we see on YouTube all the time, all the videos that I do, right? When you're doing things unlawfully. So again, everybody's going to be different. And let's talk about that. In the video, they first mentioned training standards need to be higher. I 100% agree with you, right? And the reason why that's important is because the only way to adhere to standards is to actually know what the standards are. So if you have no idea what the standards are, how can you adhere to the standards? You can't adhere to the standards if you're not trained on the standards. So training is absolutely huge. It's a big pillar of that, and it's a very important pillar of that. And I believe that training is a cornerstone of what needs to be done. With that being said, again, adhering to standards, and everybody's going to have different standards. I have standards for myself. Some people say they're high. My standards are that's my standard. So for me, like I said at the beginning, every element is going to be tied to a court case precedence. And the more I do this, the more Supreme Court case, because I'm learning every single day. The difference between me and most other people is I study law. I study case law. I study Supreme Court case precedents, 10th Circuit state case precedences. I study it and I go over it so much that, wow, to a person who's starting from the ground up, yeah, that might seem like a really large task. For me, again, I'm serious. It's literally copy and paste. Every element that I have for reasonable or articulable suspicion, every element that I have for probable cause, all of them are all tied to court case precedences. So again, it could be something as simple as nervousness. Nervousness has multiple Supreme Court case precedents that say, yes, excessive nervousness is an element of reasonable suspicion or probable cause. And there's a bunch of them. So copy and paste, right? And I have a whole template. Again, they're all there. Now, again, for you starting out, that may seem super hard. Cool, man. As you do this, you're going to write more and more reports. So again, take that for what it's worth. I'm not here to recreate the wheel for you. I'm just here to tell you what the reality is. So again, all that to say, I have no idea who these anti-hero podcast people are or who the Copville people are. It's like a lot of things in social media. You give somebody a podcast or a social media account and they can kind of say whatever they want, but they're free to spew their misinformation and inaccuracies, and I'm free to just present the case law. Because again, don't believe me, right? Don't believe any cop you hear. Don't believe it, and don't believe me. But I've presented you with numerous receipts. Take those receipts and do what you want with them. And again, you can always hire an attorney because that's what they get paid the big money to do. Hire an attorney, talk to them about it. I'm sure they'd be more than willing to have a conversation with you, given the right price. So again, hope this video was helpful for you guys. If you have any questions, leave in the comment section below. Most importantly, tell me what you think. What do you think of this? What do you think of qualified immunity? Do you think most people know what qualified immunity is? Do you think most cops know what qualified immunity is? Has this changed your perception on qualified immunity? I want to know, and I want to hear from you in the comment section. Long live the Republic.